Imagine waking up one morning and discovering that every single justice on the United States Supreme Court, all 9 of them, from the most conservative to the most liberal, agreed on something. Now imagine that this rare, virtually impossible consensus just shattered decades of assumptions about gun control, police powers, and the reach of government into your home. What if I told you this didn't just happen once, but twice in recent years, and the shockwaves are still reverberating through courtrooms, police departments, and Second Amendment debates across the entire nation? In an era where the Supreme Court can barely agree on what day it is, let alone constitutional interpretation, these unanimous decisions send a clear, unmistakable message that has gun control advocates scrambling and constitutional scholars rewriting their textbooks. The question isn't whether these rulings changed everything. It's how much damage they did to the regulatory framework that's been built up over generations. And here's the thing that should terrify anyone who supports expanded gun regulations. When even the justices typically sympathetic to gun control voted to strike down these measures, something seismic just happened. If you're passionate about Second Amendment rights, constitutional law, just want to stay informed about decisions that could affect millions of Americans, hit that subscribe button right now and smash that like button. Trust me, you don't want to miss what's coming next in this ongoing legal battle that's reshaping America. Let's talk about what just happened, starting with the most recent bombshell that dropped on June 5, 2025. The case was called Smith & Wesson Brands versus Estados Unidos Mexicanos. And yes, that's the Mexican government suing American gun manufacturers in U.S. courts. Think about the audacity of that for a moment. A foreign government attempting to hold American companies liable for crimes committed by drug cartels in Mexico with firearms that were legally manufactured in the United States. The Mexican government was seeking billions with bin damages, claiming that Smith & Wesson, Barrett, Beretta, Colt, Glock, and other iconic American firearms manufacturers were essentially complicit in arming the cartels. Their argument was that these companies knew their guns were being trafficked across the border and did nothing to stop it, making them accessories to murder, kidnapping, and drug trafficking. On paper, it sounded like they might have had a case. After all, everyone knows guns flow south across the border. The Mexican government claimed that up to 90% of firearms recovered at crime scenes in Mexico originated in the United States. They had statistics, they had examples, they had horror stories about cartel violence. What they didn't have was a legal theory that could survive scrutiny from all 9 Supreme Court justices. Here's where it gets interesting. There's this federal law called the Protection of Lawful Commerce in Arms Act, or PLCA, that Congress passed back in 2005 specifically to stop these kind of lawsuits. Congress had watched as activist groups and government entities tried over and over to sue gun manufacturers into oblivion for crimes committed by criminals using their products. Think about how absurd that premise is for a moment. Should Ford be liable every time someone uses an F-150 to commit a crime? Should kitchen knife manufacturers be dragged into court every time there's a stabbing? Of course not. But gun manufacturers were being targeted with exactly this kind of logic, and it was bankrupting companies and chilling the entire industry. So Congress stepped in and said enough is enough. PLCAA created a shield protecting firearms manufacturers and sellers from being held liable when third parties misuse their products. It's basic common sense. You can't hold someone responsible for what a criminal does with a legal product. But Mexico thought they had found a loophole. PLCAA has what's called a predicate exception, which means if a gun manufacturer knowingly violated a state or federal law related to the sale or marketing of firearms, and that violation proximately caused the harm being complained about, then a lawsuit can proceed. Mexico's lawyers crafted this elaborate theory that the gun manufacturers were aiding and abetting illegal gun sales because they supposedly knew that some dealers were selling to traffickers and they didn't do enough to stop it. They claimed the manufacturers deliberately supplied guns to what they called bad apple dealers, that they failed to impose proper controls on their distribution networks, and that they even designed and marketed guns specifically to appeal to cartel members. They pointed to things like 50 caliber sniper rifles, guns with Spanish language names like the Colt LG pistol, and firearms with imagery celebrating Mexican revolutionary Emiliano Zapata. In Mexico's view, this was all evidence of a conscious conspiracy to arm the cartels. The problem? The Supreme Court didn't buy a single word of it. Justice Kagan, writing for unanimous court that included every ideological stripe from Justice Thomas to Justice Jackson, systematically dismantled Mexico's entire case. The court explained that to aid and abet a crime under federal law, you have to take affirmative action to further that crime, and you have to intend to facilitate it. You have to participate in the wrongdoing is something you wish to bring about and actively seek to make succeed. That's the standard from decades of criminal law, and it's a high bar. Mexico couldn't meet it. Not even close. Think about the structure of the gun industry for a moment. Manufacturers don't sell directly to retail gun stores. They sell to wholesale distributors, who then sell to retailers, who then sell to customers. Mexico never even alleged that the manufacturers had direct relationships with the so-called bad apple dealers. They couldn't name a single one of these dealers. They couldn't point to specific illegal transactions. They couldn't show that manufacturers were treating rogue dealers any differently than legitimate ones. What they had was a vague, generalized accusation that somewhere in this massive distribution chain, somebody was doing something wrong, and therefore the manufacturers should pay billions of dollars. The Supreme Court looked at this and said it's nothing more than indifference, not assistance. It's nonfeasance, not active participation. The court compared Mexico's case to a recent decision called Twitter versus Tamna, where victims of an ISIS terrorist attack tried to hold social media companies liable because ISIS supporters used their platforms for recruitment and fundraising. The Supreme Court said no, providing a general service that bad actors sometimes misuse doesn't make you an accomplice to their crimes. The same principle applies here. Gun manufacturers can't be held liable just because they know that statistically, somewhere among millions of legal transactions, some firearms might end up being misused. That's not aiding and abetting. That's just the reality of operating in a world where criminals exist. And here's the thing that really matters. All 9 justices agreed. This wasn't a 5-4 split along ideological lines. This was unanimity. Justice Sotomayor, Justice Kagan, Justice Jackson, all voted with the conservative justices to throw out Mexico's lawsuit and reaffirm that Pulse means what it says. The implications are staggering. For years, gun control advocates have tried to use the courts to accomplish what they couldn't achieve through legislation. They've sued manufacturers, they've sued dealers, they've sued everyone they could think of, trying to create liability where the law says none exists. This decision slams the door on those efforts. It makes crystal clear that you can't hold gun manufacturers responsible for crimes committed by third parties unless you can prove they actively participated in specific illegal transactions with intent to facilitate those crimes. That's an incredibly high standard, and it should be. The alternative would be the destruction of a lawful American industry through death by 1,000 lawsuits. Mexico was seeking billions. How many similar lawsuits were waiting in the wings if this one had succeeded? How many cities, states, and activist groups were watching to see if they could replicate this strategy? The Supreme Court's unanimous decision killed that entire litigation strategy in its tracks. But wait, there's more. This isn't even the only recent unanimous Supreme Court decision that's rewritten the rules on guns and government power. We need to rewind to May 17, 2021, and talk about a case called Caniglia versus Strom. This one's even more fundamental because it doesn't just protect gun manufacturers, it protects your Fourth Amendment rights and the sanctity of your home. Edward Caniglia was having a bad day. Actually, he was having a really bad day. He got into an argument with his wife at their Rhode Island home, and during that argument, he put a handgun on the dining room table and said something along the lines of "shoot me now and get it over with." Now, obviously, that's not good. That's the kind of thing that understandably worried his wife. She left, spent the night at a hotel, and the next morning when she couldn't reach her husband by phone, she called police to ask for a welfare check. The police showed up, talked to Caniglia on his porch, and decided he might be a danger to himself or others. They called an ambulance, and Caniglia agreed to go to the hospital for a psychiatric evaluation, but only after the officers allegedly promised they wouldn't confiscate his firearms. Spoiler alert, they confiscated his firearms anyway. Once Caniglia was in the ambulance, the police went into his home, found his guns, and seized them. No warrant. No exigent circumstances that they claimed. Just a decision that they knew better, and that public safety justified entering his home and taking his property. Caniglia sued, claiming the officers violated his Fourth Amendment right to be free from unreasonable searches and seizures. The district court ruled against him. The First Circuit Court of Appeals ruled against him. Both courts said the police were engaging in what they called community caretaking functions, a doctrine that had been recognized for things like checking on disabled vehicles on public highways, and that this justified entering a home without a warrant. The Supreme Court said absolutely not. Not just no, but hell no. And they said it unanimously, 9-0. Justice Thomas wrote the opinion, and it's a master class in defending the sanctity of the home. The court acknowledged that, yes, police officers perform many non-criminal law enforcement functions in modern society. They help with accidents, they check on disabled vehicles, they render aid in emergencies. But the court made crystal clear that recognizing these community caretaking tasks is not an open-ended license to perform them anywhere, especially not in someone's home. The Fourth Amendment's core guarantee is the right of a person to retreat into their own home and there be free from unreasonable governmental intrusion. What's reasonable for vehicles on public highways is completely different from what's reasonable for homes. The court pointed out that the opinion creating the community caretaking concept explicitly and repeatedly stressed the constitutional difference between cars and homes. Here's what makes this decision so important. The First Circuit had created what the Supreme Court called a freestanding community caretaking exception to the warrant requirement that applied equally to cars and homes. That's terrifying when you think about it. Under that theory, anytime police decided someone might need help or might be a danger or might be having a mental health crisis, they could just walk into your home without a warrant, without consent, without exigent circumstances, and do whatever they thought was appropriate. The Supreme Court burned that theory to the ground. All 9 justices agreed that the Fourth Amendment doesn't work that way. You don't get to bypass constitutional protections just because you're acting with good intentions. Now some of you might be thinking, but wait, what about genuine emergencies? What if someone really is in danger? The Supreme Court addressed that too in the concurring opinions. Chief Justice Roberts, joined by Justice Breyer, emphasized that nothing in the decision prevents police from rendering emergency assistance to someone who is seriously injured or threatened with immediate harm. That's already covered under the exigent circumstances doctrine. Justice Kavanaugh wrote separately to elaborate on this point, giving concrete examples of situations where police can and should enter a home without a warrant. If someone calls 911 saying they're suicidal and have a gun and then don't answer the door when police arrive, officers can enter. If an elderly person who's never late misses appointments and doesn't answer repeated calls or knocks, officers can do a wellness check. These are real emergencies where immediate action is reasonable. What isn't reasonable is what happened to Caniglia, police deciding after a conversation that they know better than he does what's good for him, promising not to take his guns, and then taking them anyway the moment he's gone. The implications of Caniglia are profound and they extend far beyond gun rights, although the gun rights implications alone are enormous. Think about red flag laws that have been proliferating in various states. These laws allow police to seize firearms from people deemed to be a danger to themselves or others, often based on nothing more than an accusation from a family member or acquaintance. Justice Alito specifically mentioned red flag laws in his concurring opinion, noting that the court wasn't addressing their constitutionality in this case, but that provisions of those laws may be challenged under the Fourth Amendment. That's not an invitation, that's a warning. If red flag laws authorize the kind of warrantless home entries and gun confiscations that happened to Caniglia, they're on constitutionally shaky ground, but this decision matters for everyone, regardless of whether you own guns. It reaffirms the fundamental principle that your home is your castle. The government doesn't get to decide that public safety or community caretaking or good intentions override your constitutional rights. There has to be a warrant or consent or true exigent circumstances. Not a hunch, not a concern, not a desire to help. Actual, objectively reasonable belief that someone is in immediate danger and action must be taken right now. That's a critical distinction, and 9 justices agreed on it. Let's connect the dots between these two cases because together they paint a comprehensive picture of how the Supreme Court is approaching gun rights and governmental power in this era. Smith and Wesson versus Mexico reaffirms that gun manufacturers can't be held liable for the criminal misuse of their products by third parties unless there's actual aiding and abetting of specific illegal acts. That protects the Second Amendment right to keep and bear arms by ensuring that the industry enabling that right can't be litigated out of existence. Caniglia versus Strom reaffirms that gun owners and all citizens have Fourth Amendment protections against warrantless searches and seizures in their homes, even when the government claims it's acting for their own good. Together, these decisions create a constitutional framework that takes both the Second and Fourth Amendments seriously, not as second-class rights that can be overridden whenever someone feels nervous about guns or safety. The unanimous nature of both decisions is what should really grab your attention. We're living in an age of polarization where the Supreme Court is often divided along predictable ideological lines. Gun cases usually split 5-4 or 6-3, with the conservative justices voting to protect gun rights and the liberal justices voting to uphold regulations. But not these cases. In both Smith and Wesson versus Mexico and Caniglia versus Strom, every single justice voted the same way. Justice Sotomayor agreed with Justice Thomas. Justice Kagan wrote the opinion striking down Mexico's lawsuit. Justice Jackson concurred in protecting gun manufacturers from liability. Justice Breyer joined Justice Roberts in emphasizing that coniglia doesn't prevent legitimate emergency responses. When you get that kind of unanimity on issues touching gun rights and government power, it tells you that the legal questions aren't even close. The arguments being advanced by gun control advocates and government officials in these cases were so far outside the bound of established constitutional law that they couldn't persuade a single justice to their side. What does this mean for the future? It means the playbook that gun control advocates have been using for the past 2 decades is obsolete. You can't sue gun manufacturers into oblivion because PLCAA is real, and the Supreme Court will enforce it unanimously. You can't rely on expansive theories of community caretaking to justify warrantless gun confiscations because the Supreme Court has rejected those theories unanimously. You can't count on sympathetic lower court judges to carve out exceptions and special rules for firearms cases because the Supreme Court is watching, and it's willing to step in and reverse those decisions in the strongest possible terms. The strategy of using courts to accomplish through litigation what can't be accomplished through legislation has hit a brick wall, and that wall has 9 justices standing behind it. Does this mean all gun regulations are unconstitutional? Of course not. Both opinions are careful to note that reasonable regulations, proper warrant procedures, genuine exigent circumstances, and laws that actually address real problems rather than trying to backdoor around constitutional protections remain valid. What's invalid is trying to blame manufacturers for crimes they didn't commit, trying to enter homes without constitutional justification, and trying to erode fundamental rights through creative legal theories and good intentions. The Supreme Court has drawn clear lines, and it's drawn them with a unanimous agreement of justices who agree on very little else. And so where does this leave us? For gun owners and Second Amendment advocates, these decisions are enormous victories that provide strong precedential protection for years to come. Unanimous Supreme Court decisions are incredibly difficult to overturn or distinguish. They represent settled law in the strongest possible sense. For gun control advocates, these decisions represent a reckoning. The strategies that seemed promising, targeting manufacturers, expanding government caretaking powers, chipping away at constitutional protections one case at a time, have been definitively rejected. If there's going to be meaningful gun regulation in America's future, it's going to have to come through the legislative process, and it's going to have to respect the constitutional boundaries the Supreme Court has reaffirmed. And for all Americans, regardless of where you stand on gun policy, these decisions reaffirm that constitutional rights matter, that the government can't simply override them based on policy preferences or good intentions, and that the courts will enforce constitutional limits especially when, doing so is unpopular with certain constituencies. These Twin 9-0 decisions don't just destroy specific arguments made in specific cases. They destroy the entire framework of assumptions that's guided gun control litigation for a generation. They establish that the Second Amendment is a real right that gets real protection. They establish that the Fourth Amendment applies with full force even when guns are involved. And they establish that there's a unanimity on the Supreme Court about basic constitutional principles that goes beyond the ideological divisions we see in so many other cases. The reverberations from these decisions will be felt for decades. Every time a plaintiff tries to sue a gun manufacturer for a criminal's actions, Smith & Wesson versus Mexico will shut them down. Every time police try to enter a home without a warrant based on vague caretaking justifications, Coniglia versus Strom will stop them. Every time a lower court judge tries to create a gun-specific exception to normal constitutional rules, these unanimous Supreme Court decisions will remind them that constitutional rights don't disappear just because firearms are involved. That's not just important, that's transformational. It's a restoration of constitutional principles that have been eroding for years, and it's been accomplished with the agreement of justices across the entire ideological spectrum. Oh, there you have it. 2 Supreme Court cases, both decided 9-0, both involving guns and government power, and both fundamentally reshaping the legal landscape in ways that gun control advocates never saw coming and still haven't fully processed. These aren't narrow technical decisions that only lawyers care about. These are broad constitutional pronouncements that affect millions of Americans and will influence countless future cases. They represent the Supreme Court at its best, protecting constitutional rights, checking government overreach, and doing so with a level of consensus that transcends partisan divisions. What do you think about these decisions? Do you believe the Supreme Court got it right in protecting gun manufacturers from liability for crimes committed by third parties? Do you think Caniglia's Fourth Amendment rights were violated when police entered his home and seized his guns? More broadly, where do you think the balance should be between public safety concerns and constitutional rights? Drop your thoughts in the comments below. I want to hear from both sides of this debate because these are issues that affect all of us. And if you found this deep dive valuable, hit that like button and subscribe for more content analyzing the Supreme Court decisions that shape our rights in our country. The legal battles over the Second Amendment and government power are far from over, and you're going to want to stay informed about what comes next. Thanks for watching, and I'll see you in the next one.